Good evening, everyone. I'm Teresa Barnett. I'm a senior deputy prosecutor here in San Juan County. And so I handle all the felony cases, which generally includes all the sexual assault cases. So I'll tell you a little bit about how a case progresses through our system. And every case, of course, is different and unique, but I'll give you the general steps of how we approach these cases. So initially, my entry into the case comes about usually two different ways, either through the sheriff's office or sometimes victims will reach out to me independently. And I'm always happy to have those conversations. Either victims reach out directly or sometimes through a trusted person that they know in the system or through a victim advocate. And I can tell them a little bit about what I'm going to tell you guys tonight. And then ultimately, I will arrange for them to report to the sheriff's office if they're ready to do so. I don't conduct investigations on a case, but I work really closely with the detectives. So when the case comes in, as Ray and Lucas just told you, they'll take the initial reports and then they'll be coordinating with me about next steps and possible issues. And so I'll give them legal advice sometimes, and then we'll talk about the best way to go forward on a case. So, but generally speaking, they're going to prepare the case and investigate it. And then once it's ready to go, then they'll send it to me. So when something comes to my office, I will review a case for charging and then make that ultimate felony charging decision, because that's how felonies come to us as a referral from the sheriff's office, and then prosecutors decide what is going to ultimately be charged. And we do that in close connection working with our detectives as well. So in my office, I will be reviewing a case. I have a legal assistant that helps me compile everything. And we also have two victim advocates. And our victim advocates are a little bit different than the advocates at SAFE San Juan, even though they all work very closely together. SAFE San Juan is more of a community-based advocacy, and ours is a system-based. And so really the difference between our advocates is that our advocates will help victims through the court process, helping them stay informed about where a case is in the process. If they can't get a hold of me, they can always reach one of our advocates. And we provide a lot of the same services. We don't have the same confidentiality that SAFE San Juan has. And so we can do some of the same things, but also different things. So I think it's just it's a bigger package that we can then help victims when they do report. So our victim advocates are notified when cases come in, and they'll help me to reach out and set up interviews and talk to victims and their families. So just depending on how the case is presented, if it is an immediate reporting case where there's an arrest made at the outset of it, then those decisions need to be made a lot faster. Whereas other cases, we're going to wait until an entire investigation is completed and then make a charging decision at the end. And those decisions are always going to be a case-by-case basis. So it just depends on what is happening and what are the needs of the victim and what are the needs of the case. But in every case, we take a victim-centered approach. Washington is a state that has crime victims have rights, and it's in our statutes. So being mindful of that, we maintain good communication with victims and survivors and always keeping them informed. One thing that we don't require victims to do is make decisions. So we want victims to have the support and the services they need to heal. And we're going to help provide them with those resources and help them along the way, but we're not going to put the burden of the prosecution or the investigation on them. That's going to be our job, and we're going to take that. So in that victim-centered approach, we will keep victims informed and notify them and talk to them about a case as it comes in, explaining the different possible charges, and and getting their thoughts on that, explaining what the process could mean to them. When a case is charged, there's always the possibility that they're going to have to testify in court. And so we talk about that very early on. And we talk about what that means and what it looks like at every step of the way. And what I always tell people is it's never going to happen in a moment's notice. Before you ever get into court and have to talk about this, we're going to spend a lot of time together talking, and we will prepare you. And so those decisions are a long way down the road. But we talk about all those sorts of things at the beginning of the case and answer, as many questions as a person has. So then we come to the charging decision. And like I said, it's just going to depend on what happened and what we can prove. And so we try to evaluate as much as we can when coming to that decision. Ultimately, when I make the decision to prosecute, the standard that we're looking at on these types of crimes, when it's a crime against a person, is would a jury convict when considering all of the evidence? Is there sufficient admissible evidence to convince a jury that the suspect did it? And so we look at that very seriously when it's a crime against a person. So after that decision is made and a case is filed, there is a first appearance. And like I said earlier, it can depend a little bit on how the case comes in initially, but generally a first appearance in a case will be the time that the suspect, who is now a defendant, first appears in court. And that could either just be a first appearance when we're going to talk about their conditions of release, or it could be their arraignment, which is the time when they enter their plea of not guilty, always not guilty, and then we go from there. But that is the entry of the plea. And then the case progresses. Now, all of these things have different timelines. And even from the initial referral into our office, it can take time to evaluate cases and review them. And then also once a case gets started, there's different timelines. We've been challenged in the last couple of years by those timelines. There have been a lot of slowdowns due to COVID, and it's been hard on victims, and we're very mindful of that. And we always try to elevate crimes where there's people involved as opposed to property issues. So given that, we start through the court process and we enter any no contact orders that need to be entered. And we can do that sometimes before cases started, even before it's filed. Our victim advocates can help victims get orders outside of a criminal case. So once we get into court and we start through the process, there'll just be a series of court dates. We provide discovery, which is the formal sharing of information with the defendant and the defendant's attorney. So what's important for victims to know in that process is that in a sexual assault case, your identity is going to be protected in formal court documents. We will use initials and dates of birth to identify. Names may be used in open court, but in written documents, it's always going to be an initial. And we try to protect your privacy that way. All children's names are going to be also through initials and dates of birth. As far as images in child sex assault cases where there are photographs, those images are always going to be retained by the sheriff's office and protected. So they're never going to be released. And then at the end of the case, they can be destroyed with court permission. Those can be shown to the defense attorney, but it has to be seen in the sheriff's office so that those images are never released again. Other sensitive images of victims, we can redact them in our office. And then once they are shared with the defense attorney, they do have their own obligations to not then just release those. So we're mindful of those considerations and we try to protect privacy that way. As the case progresses, again, our victim advocates and I am going to be in contact with victims, witnesses, survivors, and keep you informed of how the case is progressing and any concerns that you have going forward. And it's an ongoing process. And we spend a lot of time talking to people and just explaining what we're doing and why. So when a case finally gets to the end and it's resolved either through a trial or a guilty plea, again, it is victim-centered, and we want to work with victims to get restitution ordered from the court. We want to provide you a forum to provide a victim impact statement if that is what you desire, and our victim advocates can help you with that. But there's a lot of different things that go into that. That is essentially what we do in a nutshell. And if you ever have specific questions and you want to talk to me privately, I'm always happy to take phone calls or have meetings and talk to people if they're wondering about reporting and they just have questions or concerns. I do that often, and there's been many young people and adults that have come to me, and we've had conversations, and some eventually report and some don't, but they're informed in their decision, and that's really what our goal always is to inform you and make sure you're comfortable with what we're how we're progressing in a case. So that's all I have. Thanks, Courtney.
Thank you. And while I get all my stuff settings off. Okay, thank you so much. We are going to open it up to questions now. So if anybody has a question for any of the presenters, please use the raise hand feature and we will go ahead and unmute you to ask your question. I see that some people are putting questions in the chat. And I am responding to those as we go. So at this point, does anybody have a question for any of the presenters about any of the information?
Courtney, I think your response only went to the panelists.
Gotcha. Okay. And that is okay. I actually don't have it set to go to the participants. So if you did ask a question that we can't answer in this webinar, then I will provide the contact information for the correct person to ask that question to, and their contact information. So I will start off with a question. So Teresa, can you explain to us what kind of protections that you get in a no contact order and what that entails for a victim?
Sure. So it depends specifically on what a judge orders in court, but in a general sense, it's going to be a stay away order that prevents a suspect defendant from having contact within a certain number of feet. Usually we start with 1,000 feet, and it prevents any types of communication, written, verbal, any kind of communication at all. And those are modified sometimes to change to written communication allowed as people progress. And after a cooling off period, sometimes people want to have written communication if they have children in common, that sort of thing. But we generally start off with no contact of any sort, and then go from there, depending on what the person wants.
Perfect, thank you. And I apologize, someone just brought it to my attention that when I'm responding to the chat, then I am not responding to the attendees. So there was a question asked about a case that has been ongoing, and I will just direct that person. That question needs to be directed to Teresa. You can reach her at the prosecuting attorney's office. I'm going to say her number slowly. So 360-378-4101.